Welcome to the DisabiliTEA, a podcast where we have candid discussions about all things related to disability. Short-term, long-term, financial claims, impact on other areas of life, causes in the workplace, and more. With your host, attorney Anjel Burgess. You can find this show at www.disabilityhelpline.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. Now here's the host of the DisabiliTEA, Anjel Burgess.
Hello, everyone, and welcome to another episode of the DisabiliTEA. Today, we have a very special guest with us, attorney Nicola Robinson from the SR Law Group. Welcome.
Thank you. Thank you so much for having me.
Well, we are really excited to have you today so that we can learn some more information about a really, really important topic. Nicola is an estate planning attorney, and so she is going to talk with us about all the things that we need to know regarding estate planning. So thank you again for joining us.
This is my favorite topic, so I'm excited.
I bet it is. Let's start off just talking a little bit about yourself. Just tell us a little bit about you and your firm.
Sure. So the SR Law Group is located right outside of Atlanta. We're west of the city. We're in Douglasville, Georgia. So I tell people if you've hit the Alabama line, you just passed us, because most people don't come this far. But it is the SR Law Group's been around for 5 years. It's me and my law partner, Olivia Smith. And we exclusively do estate planning, elder law, and probate. So we handle putting the documents in place if there is disability or if there is a need for what we say the incapacity documents. And then we also do the documents that are needed in the event somebody has passed away. And so, yeah, that's what we do here.
Excellent. So even though you all are in Douglasville, is it correct that you can help clients anywhere in Georgia?
Yes, so most of our clients travel from all over. We get clients from Augusta, Columbus, Kennesaw, you name it, and even our probate side of our practice. So when people don't have their estate planning documents and we do need to go to court, we represent clients in all 159 counties.
Excellent. So let's talk about estate planning. I know that word or those words kind of strike fear in a lot of people because there are things that they don't really understand. But what does it really mean to have an estate plan together?
Sure. So I think a lot of people get even, I don't want to say scared, but they get nervous when they hear the word estate because their first thought is, I don't have anything. An estate, you think the Vanderbilts or the Rockefellers or, people who've amassed this great wealth. Whereas we try to explain to people, really anybody over 18 that owns something. So whether it's a car, whether it's a couple of bank accounts, whether it's a home, especially if it's a home, those are what we would consider part of your estate. You can have all kinds of things. You can have stocks and investment accounts, but some people modest, means it may be just I have a bank account in the house, and that is still considered your estate and still requires some forethought as to what would happen to those things if something were to happen to you. And I'm not just talking about death, but let's say you had a stroke or a heart attack. You're still here, but we need a plan in place that would address who would write bank, who would go to the bank, who would write the mortgage check if you could not do that anymore. So that's all a part of estate planning.
So when I think a lot of people think about, those important documents, I know a lot of times I'll hear people say, well, I don't have anything to fight over. There's nothing to leave anybody. I don't need those kinds of documents. Can you give us an example or two of why someone would, even if they don't have a lot to leave, why they would need to have documents in place in the event or when they do pass away?
Well, I would challenge everybody to think of this as not just focusing on death. Let's not focus on when you pass away. I tell people, we always make a stop to another location before death, and that's usually sickness. And that is where we see a lot more of the fighting and the turmoil because maybe there was no plan in place as to who would physically be taking care of you or who would be managing your assets for you. So maybe you don't have a whole lot, but there's no plan. There's nobody to actually make sure that your bills are getting paid. And so sometimes we try to get people to focus on even just that part of planning. But let's say you don't have a whole lot, like you say. But normally when people come in here and I sit down, I said, well, do you own a home? And they're like, yeah. I said, well, what's the value of the home? Oh, it's probably about 500,000. That's a lot because
Oh,
that's something somebody can fight about. So it might not feel like a lot because you don't have 500,000 sitting in your bank account,
mhm.
but that home is usually the largest asset in most people's estate. And that can lead to fighting, especially if you have, multiple kids, if you have a blended family. Family dynamics are all so different.
Mhm.
Maybe you're estranged from your children, or maybe one has amassed a whole bunch of wealth and you're like, well, they don't even need it. Well, then you can make a plan for it to go to someone else who may, benefit from that $500,000 home. So it's thinking about, oh, maybe I don't have a lot in my bank account, but here's the things that I do own and what their value is. Mhm.
And what happens if, let's say, someone who does have a $500,000 home, um, they pass away, but they didn't have, a will or they didn't have a plan in place for when they pass away. And let's say they have adult children, then what happens?
So the state of Georgia it has its own default estate plan for you. If you don't put something in place, the state of Georgia has a plan. You may not like that plan, or your family may not like that plan,
Right.
but you've left us nothing else to work with. And so that's the default that the state has come up with. So if you pass, let's say you own that $500,000 home, maybe you're married, but the house is not in your spouse's name. Let's say you just bought it before you got married, or whatever the case may be. Well, under Georgia law, the spouse is entitled to no less than one third of that estate. And then the children would divide the other two-thirds among themselves. And so, again, here, let's say it is a second marriage. You
Mhm.
have second, spouse from second marriage who might not be the parent of those adult children, all
Right.
now own this property together. And sometimes that can lead to a lot of discord, especially if the children are like, we want to sell. That was our mom's house and we're ready to move on and have closure. And dad's like, but wait, I live here. And they're like, yeah, you need to move out. And so you can see how very quickly, when there's no conversation and no plan in place, how that can lead to a lot of fighting among family members.
Sure. So is that an example? I know earlier you were talking about, like the document side, and then you were talking about the court side, the
Mhm.
probate side. So would that be an example of, what could have been solved or established with documents now may have to go to court because there were no documents?
Absolutely. So yes, you could have done a will, you could have done a trust, you could have made a plan as to what would happen to that property. Instead, when there is no will in place, you die intestate, and now we have to go through the probate courts in order for the court to say who is going to rightfully get whatever percentage of that property.
Okay. Well, you just threw out two really important words that I do want to talk about. You mentioned a will and you mentioned a trust.
Mhm.
Um, what is the difference between a will and a trust?
Great question. So, oh, they do the same thing. At the end of the day, a will gets property from a dead person to the living. Same thing with the trust. You will be able to pass property from a dead person to the living. It's just how they go about it. So the will, you would name whoever is going to be your executor, who is going to be the person who essentially ties up your affairs, who gets your affairs in order after you have passed. The will is only valid if it goes through probate court. So I always tell people that is your ticket to court. And people
Mm,
are always so shocked about that. Like, oh, I thought if I did a will, we could avoid all of that. And that's not true. It's only valid when a judge says it's valid. And so your family members, after you pass away, they're going to have to take that will to probate court. Then the judge says yes or no if it's valid. That gives an opportunity for maybe some hurt feelings family members to step up and say, no, she meant to leave it to me. And I was her favorite, or whatever the case may be. So then there's the time for objections, and then those might require hearings because the judge has to kind of sort through all of this. Well, sometimes we get surprise children, all that kind of stuff happens, and so they all need to be addressed. Then after all that is addressed, then we publish for any creditors that the person might have. And so if creditors have claims, let's say you left at, you died, Amex, you still owe $10,000. It doesn't go to the grave with you. People really think that that's going to be the end of it. But if you left any assets, Amex has the right to try to recover any money that you may still owe them. And so in the state of Georgia, if you have any outstanding medical bills after you pass, if you had any IRS debt when you pass, if you had any legal bills when you pass, those all have to be addressed and dealt with. And so sometimes the house might be the only asset and it has to be sold in order to deal with those debts. And then only after that do we turn to the will and say, okay, did she leave the house to the kids, or who did she leave her things to? And so that's how the will side of things go.
okay.
Trust work a little different. And this is why most people say, oh, I want to trust, because it's private. So we don't have that whole court proceeding. We don't need a judge to say it's a valid document. We don't need to publish for any creditors. Instead, you create the trust. You may have transferred those assets into the trust. So if it's a property, you've retitled it into the name of the trust. So the trust actually owns those assets. And within the trust documents, it says exactly what's going to happen to those assets after you have passed away, or even if you've become incapacitated. So, one of the things I like about a trust versus necessarily a will is there's room to put language for incapacity. So, we know exactly who would continue to manage the properties that are in that trust, whereas the will only valid after you're dead. So there's no
Okay.
room for incapacity planning under
I
a
see.
will. So even with the trust, whoever you've named to manage everything, which is called a trustee, they pick up the trust documents. They say, okay, house to my children or house to my husband. And then their job is to follow whatever language is in the trust document. So they would transfer that property to whoever you have designated. So from a time frame standpoint, a lot of times people ask, okay, well, how long would it take if I did a will and go through the court process?
Mhm.
It really depends. I mean, we're still finishing up cases that passed during the pandemic. And so why that is significant is if you left a property via will, let's say you left a property to your children, and there's a mortgage still on that property.
Mhm.
Well, while we're in probate court, the expectation is somebody needs to pay that mortgage.
Right.
If you didn't leave any cash enough to pay, 6, 7 months worth of mortgage, somebody will need to pay that until the estate can get to the point where it either needs to sell the property or transfer the property. And so a lot of times what I see is the children say, we weren't prepared to pay mom and dad's mortgage, we got our own mortgage. And
Right.
unfortunately, that property ends up is still going to be foreclosed on. And so
Mm.
sometimes in that process, you can see families still lose the largest asset because we don't have a true timeline of how long the courts will take.
So, what would be the advantage then to having a will over a trust? So, why not just
Um,
have a
I
trust?
think the most obvious advantage is the will is less in costs on the front end in preparation. So in preparing a will, it is genuinely most attorneys, I would say, it's going to be less expensive than
Okay.
preparing a trust. So costs will be minimal on the front end in preparing the will, but your family is going to have to deal with costs on the back
On the
end.
back end, right?
And so, sometimes I have to tell clients it's really who is going to pay for your affairs. You on the front end to make sure that there are no problems later on, or your family on the back end
Mhm.
if there are problems later on.
Wow. Okay. Well, that makes sense. Um, and then I guess by virtue of having a will, there's a possibility that, given the example that you just provided about wait times, right? You're thinking everything's going to be okay. The house is going to go to the kids. And, all of a sudden there's a long delay for reasons no one can control. And no one ever thought about, well, how's the mortgage going to get paid? And then,
Mhm.
you know, the house that you desire to leave to your kids is not available to them. So I think that is a really important, point to make, that it's almost like you have to prepare kind of for the worst case scenario when you're trying to get these documents together, and try to make sure, maybe there are some ways if you're doing a will to make sure that that's not going to happen. Um,
Well, if you are going to do a will, and that's the mode you want to use in order to transfer the property, make sure you have enough cash in the bank account for at least a year. But
okay.
understand that it is not an immediate access even to that cash.
Hmm.
Because think about it, and I'll give you a great example of a case that I've been in now, feels like forever. He didn't even leave a will, but he left IRAs, he left bank accounts, he had a property, it's been paid off for years. Well, his three children thought, okay, well, we'll get access to that, we'll be able to settle his affairs. Well, five other people have come forward and said that they're also his children. And so there's DNA
Hmm.
testing that needs to be done. Everybody needs to be kind of sorted out before we can even access anything he's left. And so now we're what, a year and a half, and we haven't been able to touch any of those bank accounts. So you never know what will pop up out of the woodwork. Not that everybody has, a bunch of other kids, but
Right.
there still could be somebody that comes to challenge the will and says it's not a valid will because they were either under duress when they signed it. Like, yeah, daughter A had a gun to mom's head and she had to leave her everything. Or they say that the person didn't have the capacity to sign the will. So there's a whole host of ways you can even challenge the validity of the will. And you have to get through that part first. And we don't know how long that part could even take before you could even gain access to money, even assuming there's money to pay the mortgage.
Okay.
Mhm.
One of the and that makes sense. Gosh, there are a lot of things to just prepare for, right? This is why your job is so important, to make sure that everything lines up. And
And
that
this is where I think a lot of times, because people say, I can just get a will off the internet. And I mean, there's a whole bunch of different services. I won't call any of them by name,
right,
but really my job is to counsel and to help
sure,
you kind of navigate and understand that stuff.
right.
Because there's a lot of times people are like, oh, I didn't think of that. Oh, I don't know what
That's
would
right.
happen if there's no money in the bank accounts. And so it's really having those conversations and coming up with the plan. Like, okay, if you want to use the will, what's the plan? How are they going to access the money? How are they going to pay the mortgage? And so the documents really are just kind of a memorialization of the plan that you and I have come put together through this process. Mm.
Okay. Well, what about, you had mentioned before, I think in the context of a trust, you mentioned incapacity. So
Mm.
I want to talk about that and kind of what that means and other ways that, someone may be able to prepare for, becoming sick, and maybe, you know, you're still alive, but you're not able to pay the bills and do the things that you would normally do because of your illness.
Yeah. And so that can kind of depend on the type of illness, and what incapacity means varies as well. You could be physically incapable of doing things, mentally, however the case may be. But if you put together the trust before that onset, then we now have somebody that's designated to be the person to continue to manage those assets that have been placed in the trust. And so there's language even in the trust that says, hey, use those assets for my care if necessary.
Okay.
And then after I've been taken care of and after I pass, whatever's left, here is what we do with it. Mhm.
Okay. And so when you create a trust, does it have to be funded at that time? So does there actually have to be money that you put into the trust when the document is drafted?
Yes and no. So sometimes, like I have clients, for example, who know that the bulk of their cash will come from, like, say, a life insurance policy.
Right.
And
That's what
so
I'm thinking.
that's not funds that they're going to have immediate access to, but they want it to pour into the trust. They use those funds to fund the trust. And when we say fund, that means actually putting things, retitling them, and putting into the trust itself. And so if it was a house, we would do a new deed that shows that the house is in the trust, is owned by the trust. And so
Okay.
you can use the life insurance and have it paid to the trust, or have the trust even own the policy. And so at the time of the person's passing, that check is made out to the trust itself and will be deposited into an account that's also in the name of the trust.
Okay.
So yes, you can fund it later, but if you do have a property, depending on the type of trust as well, that also dictates what we put in now versus what we put in later.
Okay. And what about if we step away from the trust and we talk about just someone who, you know, they don't want to go the trust route, they want to have a will, but they're also concerned about, well, what happens if I get sick? Or what happens if, you know, from a mental standpoint, I am not able to cognitively, make decisions and things like that. Are there documents that can be drafted to prepare for that kind of event?
Yes, absolutely. So for what we consider incapacity, there are power of attorney. So let's say you have dementia or you have a stroke and you need somebody to still go to the bank or maybe bring a lawsuit on your behalf, kind of still do the day-to-day operations. You can do a power of attorney that gives that person access to the bank accounts. Not making them a co-owner on the accounts. I caution against that. And the people are quick to do that because they'll say, oh, I'll just add my daughter or I'll just add my son. They'll make it easier.
Mhm.
Easier, maybe, but it will also cause a whole host of other problems. If that son is sued, or if that daughter has a divorce, or if that son files for bankruptcy, all your bank accounts are now considered their assets as well. And so
Right.
those will also have to be factored in. So we are always cautious of just putting children on accounts. Instead, using a power of attorney would give them access to those accounts, not making them owners, but making them, giving them the ability to still write checks and pay bills and the things that you would need them to do. And by using a power of attorney instead of just making them a co-owner, if they ran off to Vegas with the money under a power of attorney, there's recourse because they were a fiduciary. If you
Okay.
make them a co-owner, they're just an owner. So they can go to Vegas. Vegas is their money as far as the law is concerned. And so those are things that I help clients to understand.
So with the power of attorney, so let's say that someone has made me power of attorney or given me power of attorney.
Mhm.
Does that only apply if that person is no longer to make decision, no longer able to make their own decisions, or does that apply regardless as to whether they can make decisions?
So yeah, you do not have to be incapacitated in order to use a power of attorney.
Okay.
You can use a power of attorney for a whole host of reasons. We have sometimes military spouses that have been deployed and their spouse is still here. We were in the middle of closing on this property before they deployed. And so it would still allow their spouse to be able to be their agent. That's what it's
Okay.
called under the power of attorney, and they can still sign and do things on their behalf. So
Excellent.
no, you don't have to be incapacitated. Mm.
All right. So it's very important to make sure that you choose wisely then,
Very.
when you
Mm.
when you're
Mhm.
deciding who's going to have that power. And
And
I
I
guess
tell
most
people that all the time. I'm like, you don't, it's very common for people to be like, well, I'll name my daughter because she's the oldest. And I'm
Mhm.
like, that's not really the criteria you should be
Right,
using. You really need to look at who's trustworthy, who's responsible with money, who would you feel comfortable opening your bank account and your checkbook to and let them do all of your day to day. They would literally be stepping into your shoes. And so if that same oldest daughter has already filed for bankruptcy a couple of times, she might not be that great with money. And so you have to
right.
take those types of things into consideration. Who's going to be responsible and a good steward of your things?
Great point. Great point. I think most people probably um, don't give that as much thought as they should. And that's
Mhm.
where having, an attorney such as yourself, instead of trying to do it on your own online, um, online, there's nobody to counsel you, to help you make sure that you're making the right decisions, to ask you the questions, the things that you just pointed out. So I think all of that's really important and really good to know. So,
Well, I mean, I have seen those online documents, and the law is going to assume that you know what you're doing when you fill out those online documents. And we had a situation where a young man decided he wanted to get one online. He was going to help his dad, and so he was supposed to. Story goes, he was supposed to leave himself half and give his aunt half. He didn't
okay.
know what he was doing, so he left everything to his aunt. And so when his dad
Oh,
died, and he essentially disinherited himself. And so he was like, "Well, can we fix it?" I was like, "I can't go to a court and tell them you made a mistake. You were the drafter. They
right.
assume you have to assume you knew what you were doing." And so of course his aunt was like, I'm happy to get everything. I don't remember the conversation saying 50-50. I feel like my
Mhm.
brother would have wanted me to have it all. And so
Wow.
yeah. And
Okay.
yeah.
Wow. Well,
So
that's a cautionary tale.
oh, I have a million of them. I've been doing this a
I
long time.
bet you do. Well,
But there,
aside from all of the counseling that you do and the drafting and helping people to make sure that they have a good plan in place, I know that you also have a podcast. So tell us about your podcast.
so thank you for bringing it up. I have a podcast called Black Parents Aging.
Hmm,
When we first started doing this, most of my clients are 65 or above.
okay.
And so I look at not just estate planning, but elder law. I start having questions. I start asking my clients questions about, hey, if your health started to fade, like what would that look like? Is there finances in place? Are you going to stay at home? Who's going to
Mhm.
pay for that? Have you had conversations with your children who live across, country? Like how would that look? We have conversations about what are your options if you had to go into a nursing home. Are you going to private pay? Are your children going to pitch in? Are you going to apply for government benefits? If you plan to apply for government benefits, well, let's look at your assets and see whether you would even qualify. Um,
Right.
most specifically, I'm talking about Medicaid, and that's means tested. And so, if you got too much asset and too much income, you may not qualify. But there are things that we can do through trust planning that would be able to move some assets around so that down the road you may be able to qualify. And so we start having those conversations with our clients much earlier. And the more I was doing that, the more people kept asking questions. And so I needed the podcast because I needed a larger platform because I think it's just not a conversation we're having in a lot of our communities about what does that look like. We're all agreeing that everybody's living longer. We're all agreeing that the baby boomers are retiring and living, but nobody's talking about when they're getting sick and dementia and resources and assets and nursing home and all that stuff. And so that's where the podcast came from. It was a chance to really talk to kind of what we call the sandwich generation, the children of
Right.
these baby boomers who are faced with trying to figure out care for mom and dad and what that would look like financially. And maybe they're still raising their children. And so they're saving for college and they're kind of stuck in the middle of these two worlds because they're trying to be caregivers for aging population and caregivers for their minor children. And so that's really where the podcast came from.
That is fantastic. So I definitely want to check out your podcast. So where can our listeners and viewers, where can they find your podcast?
So it's on Libsyn, it's on Apple, it's on Google. I think it's on all the platforms at this
Okay.
point.
Perfect.
And if you go to our website, uh, srlaw.com, you should be able to find there's a link there for it as well. But yeah, it was really just our opportunity to start talking to children and giving them tips and tricks. I mean, I was getting asked the same stuff, like mom and dad shouldn't be driving. How do I navigate that? And trying to explain to children, like, hey, you can make an anonymous report and have them brought back in to get their driving test, and then
Okay.
they will fail them purposefully, so we can get them off the road. So
Mhm.
because you have to think about, most people have been driving since they were 15, 16. Now they're
Right.
83, 93. It's not an easy conversation to just say, I'm gonna take your keys from you. And so
Right.
helping the kids try to figure out, now that they're in the role of caregiver, how does that look? And I think there's a large psychological shift that comes along too. The parents have been strong and independent all this time and been taking care of you. Now
That's
you
right.
got to take
Raising
care
you.
of them.
Yes.
And that is not easy. They're not ready to give up that independence. And so on the podcast, we talk about just how to have those conversations with your parents, how to bring your siblings in when you
Mm.
start to see maybe cognitive decline in your parents. But it's usually dynamics where one lives close to mom and dad and see them every day, or one lives across the country. They're like, oh, they fine because they don't
Right.
talk. They might talk to them or see them at holidays, and so everybody's not seeing the same thing.
Right.
And then they're not on the same page on what needs to be done. And so we talk about how to navigate that as well.
That is wonderful. Well, thank you so much. You've shared so much helpful information today. And I think you've cleared up a lot of things for most people, including me. You certainly cleared up some things, some misconceptions that I had about estate planning. So I know that it is really valuable to our audience. Before we go, is there anything else you want to share? Anything you want our listeners and viewers to do? Just any parting thoughts?
Well, if they are thinking about doing estate planning, the first big step is to even figure out what your assets are. As simple as that sounds, you've bought property, maybe you sold property, maybe you inherited property. So, kind of finding out and figuring that out. Maybe you used to have a bank account for Christmas savings money, and then you had this vacation trip money over here. And so getting all of the assets on a piece of paper, just doing inventory, and then start giving some thought to who would manage all of this, and putting some pen and paper, putting that to pen and paper is probably the biggest hurdle for most people before they even get to me, because they haven't given any thought to this. So start there. Get organized.
All right. And how can people reach you?
So they can call our office, 404 or we're on all social media platforms.
Okay.
So SR Law, SR Law Group is the name of the firm. You can find us on Facebook, social media. I'm sorry, on Facebook, Instagram, LinkedIn. I want to say we're on TikTok, but I don't. That's not me. It's probably gonna be my law partner.
Well, you're on social media. There are plenty of platforms they can find you on for sure. Well, again, attorney Nicola Robinson, thank you so much for joining us today, and for sharing so many helpful insights and tips with our audience. I think that will be really instrumental in planning and reinforcing the need to plan that each of us has. So we really appreciate it. And again, this has been another episode of the DisabiliTEA, and we look forward to seeing you next time. Thank
you
you.
so much.
You've been listening to the DisabiliTEA with Anjel Burgess. Thank you for your positive reviews, comments, and sharing the show with others. You can catch prior episodes at www.disabilityhelpline.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more.